Good afternoon. We're going to go ahead and call to order. My name is Don Wynn. I'm a Florida bar attorney specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature. While formal rules of evidence do not apply, fundamental due process will be observed. Everyone with the case today will have the opportunity to present testimony. You may also present evidence or call witnesses to testify on your behalf. Please note that there is no public comment portion during code enforcement hearings. To speak on a specific case, you must either be the respondent or a witness called to testify. Everything said today will be recorded. All testimony will be given under oath. When you are sworn in, please state your name and provide your current mailing address so we have an updated record for sending any orders. The city will present its case first. Information may be displayed on the screens and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are objections. After all evidence and testimony have been presented, I will make a ruling. My ruling will be reduced to writing and mailed to you. We'll go ahead and move forward with swearing in any witnesses. So at this time, if you intend to testify for your case, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, thank you. You may be seated. We're going to go move forward with the lien reduction hearing that's on the agenda, and that is for 3700 Miriam Drive.
Good afternoon, sir. I'm going to enter in the lien reduction application and the cost recovery. The other deed, et cetera, that accompanies it at all.
Thank you.
This is originally was the case number 2537. The current owner is different than the original case owner, and it's a living trust with a Michael Sirocco as trustee, who is here today. The respondent in the original case was Jessica Cassell. Violation address 3700 Miriam Drive. The violations were junk and debris, overgrowth and weeds, swimming pool enclosure, and the pool itself. Okay, originally heard was needed to correct all the violations on or before September the 5th, 2025. If not, fine of $150 per day per violation would commence. An administrative cost of $128.53 were imposed. On January 27th, 2026, an inspection of property found in compliance with 1223 junk and debris and subsection 302.4 overgrowth and weeds, and the daily fines were stopped. On January 30th, 2026, the property was found to be in compliance with subsection 303.1, the swimming pool, and subsection 303.2, the pool enclosure, and daily fines were stopped. And on February 5th, 2026, the Code Enforcement Department received the application for lien reduction from Michael Sirocco, who represents the trust. And like I said, he is here today. And the application is presented with the court's Titusville City of Code Ordinances, Section 1371, for a special magistrate consideration. Total daily fines accrued were $87,088.53, with the administrative cost of $128.53 included. The applicant is requesting a reduction in the amount of $86,828.53. And this shows the latest report on the owner and the assessed value. I'm sorry, I can't make that any larger. This is an after picture of removal to overgrowth. The front of the house was completely, totally overgrown. That's some of the weeds on the backside that were part of the overgrowth. The enclosure right there, the screen was missing and the door was damaged. That has been boarded from the inside to prevent entry into the pool area. This is a little bit different. This is a before of the pool. And you can also see in this that how the enclosure was not secured. And this is afterwards. You can see what Mr. Sracco has done, has covered the pool and secured that enclosure. That was how nasty the water was before. And this is some of the junk and debris that was up around the front door and in the backyard. It was just all over the property. And that was it. The neighborhood greatly appreciated it.
All right. And, sir, you may come up. Good afternoon. Go ahead and state your name and your mailing address for the record.
Michael Sirocco, 526 Brevard Avenue, Cocoa, Florida, 32922.
Are you the trustee of, or are you the owner of 180 Aircore Drive LLC?
Yes.
Okay. All right.
I'm the manager. My wife is the owner. But
Gotcha.
yes.
All right. So tell me more.
Yeah, so Miss Leverhant was the lent money on this property years and years ago. She had went through the judicial foreclosure process. We purchased, as soon as she got certificate of title, we had already had an arrangement where I would purchase the property from her. She had made me aware that there were violations. It was beginning of January. There wasn't, the actual liens weren't recorded until shortly after I had taken property, but I was aware that there were violations. I wasn't aware as to the actual amount or what the specific violations were, but looking at the property prior to purchase, I had a general understanding. Within 2 weeks of owning the property, we made sure that we had complied with all the violations and reached out to code enforcement as soon as we possibly could.
There were no pictures of like the enclosure or anything that you had, officer, were there?
I've got plenty of pictures if you need me to.
Yeah, do you mind bringing them
Yeah,
up?
of course.
Yeah.
We found a nice gator in the pool too.
Oh, well, that's good.
They're on my phone, so I'm not sure if you want me to walk out to you.
This is,
I remember the before, because I remember the
yes,
hearing. Yeah.
that's before he tried to do it that way and it wouldn't work. So he came back, and that was before how it was. A lot of most of the screen on the door was gone. The big panel there to the side, that was gone. The rest of it was fairly secured. Door at the other end was locked, and that was after he boarded that on the inside.
We've actually since drained the pool and everything.
Oh, okay.
I got to the point where I can do everything in the property that doesn't need a permit, now I'm waiting on a roof permit so we can carry on with it.
Just show me a couple real quick of the back, and then I'll probably need you to email it to them so we can add that to evidence later. Yeah. Yeah, I don't, just swipe this way. I don't want to go through your, yeah, I don't know what you got in there, so. Okay. What's,
And then
yeah.
what we did was, we're redoing the entire enclosure, but he told me that there could be access to the pool for somebody to get in. So what we did is just boarded up all the areas that this under.
Oh, this is what it, that,
Yeah, so under 6 feet where there would need to be a fence, we just boarded everything up so no one could get access to the enclosure at all. It's all since been cleared, the pool's completely drained. And like I said, we got to the point where we've done all the work we can demolition-wise, where we don't need permits. Now we just need waiting on a roof permit and then to get the rest of the general renovation permits before we can move forward. But we satisfied all violations immediately, and I was in contact with the officer to make sure that I understood what he needed me to do, and I did it as soon as I possibly could.
so the Evelyn Leverhant Simeon, she was the lender on the property. She or her trust foreclosed on the property, and you guys had an arrangement basically to purchase it from her after the foreclosure?
Correct.
Because, yeah, I'm looking at the property appraiser site, and it doesn't have any purchase price listed out there.
Yeah, so she actually foreclosed on 2 properties at the same time. We bought both of them, and then, to be frank with you, some of the purchase price is contingent upon the amount that's reduced in this as well. So
Gotcha.
we're waiting to go back and address that.
see that the market value by the property appraiser is $308,510. Obviously, county appraisals is always a little bit less than what actual market would be, but let's just use that for right now. When I look at your application, one of the factors that we look at is obviously the relative value of the lien versus the property value. So obviously that's a substantial amount. In the application itself, I know you stated that you are aware there are violations, but not aware of the amounts.
Correct.
Obviously anytime there's a foreclosure, and obviously if you take title via quitclaim deed, there's a certain buyer beware aspect
Yes.
to it.
If I may tell you, a lot of guys wouldn't have taken that house for free, so you can call it 300,000 if you want.
No, I get it. I get it. But I can only, go with the data that I have in front of me, right?
Understood.
No, I mean, I am inclined to reduce it considerably, just again because of the relative dollar amounts, and actually I'm very happy to hear that the neighbors are appreciative of the efforts, and Officer, not Jim, sorry, I guess we're satisfied with the condition of this, but is there still more work to be done, right?
Yes, he'll have some more things to do on his end, but as far as code end, he's good right now.
I'm compliant, but it's not exactly livable.
Yeah, exactly. Bear with me one second. I'm just looking at the payoff, because what you have here,
Yeah, the
go-
foreclosure was 250.
275,000, yeah. But you're talking about a lien that's $86,000, which is obviously a substantial portion of whether you call it 275, whether you call it 300, or even less, given the condition it is. That's probably the biggest factor in what I would consider, alongside your efforts to clean things up since then, in reducing it. But you have admin costs for the city, which I'm not going to reduce.
Okay.
Lot cleaning fees, which the city has had to incur, which I'm not going to reduce. Recording fees, which aren't very much. All those together are like 300 and 400. Then the big bulk of the fines is basically 21,450 per 4 violations. Given that, I mean, I think you stated before, you're aware that violations were on there. You were certainly aware that there was maybe some sort of monetary amount there, but you didn't know how much. I think it's only fair that some of the fines remain. If we reduced it to just, instead of the multiplier of 4, so it's 21,450 times 4, it's just one of them plus all the admin costs and everything. Is that something the city?
That would be approximately 25% overall, which is about what the city was looking for as far as reduction
Yeah.
ceiling,
Yeah,
or floor, I should say.
4, yeah.
So we're just 24% away from having a deal.
You're not negotiating with me, man. Sorry. No, I mean, but again, there's while I am appreciative, I'm sure the city's appreciative, there is an element of buyer beware. And it sounds like you accounted for that with the purchase price or whatever business arrangement you have with the trustee that foreclosed. And I think you guys recognize that. And obviously, you look like and you sound like a businessman, and you're not doing this to lose money. But at the same time, I think you came in knowing that there was some risk.
Yeah, no, I was shocked
so-
when they were 87, I'll be honest.
Yeah,
Because
yeah.
it wasn't even recorded yet, so
Yeah.
in that short period, but if you got multiples, then just
Yeah.
kind of adds up.
So, yeah, I'm gonna go ahead and issue that. And again, the order that I issue was just gonna be a recommendation to the city council. So it's up to them to approve it or not. And I think you have an opportunity there to be present there when they discuss that as well. But yeah, so I've reviewed the lien reduction application in the city code provision that is applicable. Have considered documentary evidence, including photos and sworn testimony relating to the matter from city staff and the respondent. The factors that I've considered are the actions taken by applicant to correct and time it took to bring into compliance, the accrued amount of the enforcement lien compared to the market value of the property. I don't think you have any financial hardship that you're claiming. I don't think this is your homestead. And I do think you had prior knowledge of the existence of the violations, maybe not so the lien because it wasn't on there. I will recommend that City Council reduce this lien to a total of $21,450 plus, let me just use my calculator real quick. Sorry. So that'd be 225 plus 35. So that would be a total amount of $21,838.53. Does that look correct? Okay. Based on the factors I stated before. And that lien will include all the costs incurred by the city, all the admin costs, the lot cleaning fee, and the recording fee. It is so ordered. You will receive a written order from today's hearing, which will just be a recommendation to City Council. You will have notice and opportunity to attend the City Council meeting where the recommendation will be considered. And one more thing, if you can email those photos that you showed me, that will be made exhibits to the file so the City Council can see the efforts that you've made.
Okay, I can send some updated ones as well.
Okay,
so.
that'd be great.
Okay.
All right, thank
And
you,
then
sir.
is there a set time? Sometimes I know some municipalities will have like,
Yeah.
you'll have 60 days or 30 days after the order, so.
Glenn? Yeah.
Actually, after it goes to council, you have 90 days.
Oh, perfect, that's fine,
So,
thank you.
and we'll send you, once you send those, I will then take the case forward from
Okay,
here.
all right.
And get you the date when we're set for schedule.
Okay, sounds good. Thank you so much for your help.
Thank
Thank you for
you.
your time.
Thanks,
Can I have
man.
the excuse?
Yes, sir.
Okay, thank you.
All right, we will move forward with the non-compliant hearings. The first one is 25-74, which is 218 Ojibwe Avenue.
I present to you the affidavit notice of hearing for today and the cost affidavit of $189.11.
Thank you, officer.
Again, 218 Ojibwe. The mail to address was the same. It was also mailed to the California address. And for the hearing today, there were some discrepancies, I guess, in January. That it was sent to Pink Trust in Puerto Rico as well, of the notice of hearing. This is for the accessory structure for the fence and the enclosure for the swimming pool. This case was originally heard for non-compliance on January 12th. You'd requested that the SunTrust Mortgage, which is in Puerto Rico, get notified. I'm sorry, Pink Trust is listed as. Didn't get notified of the hearing, so we sent them a notification of the hearing, which they did sign and received notice of that. I spoke with Linda Sanchez of SunWest Mortgage, emailed her a couple times back and forth. She advised that the tenants received a 90-day notice to vacate on November 7th, and it expired on February 5th. And their counsel was moving forward for an eviction process. And when I checked the other day, on February 19th, they did start a proper eviction process for the tenant on this matter. As if you remember, they wouldn't do anything with the property until the tenant was gone. Again, this case was originally heard in November. They were given until December 5th. If compliance was not obtained, then receive a fine of $100 per day per violation until the violation was corrected, and an administrative cost of $189. Last week, I was notified that the contractor was out there, and they did show up and correct the problem on Thursday, which was the date, what was Thursday? The 5th. On the 5th is when it all came into compliance. They fixed the fence. The pool is damaged to unrepairable condition, so it's still there, but it's not deemed a hazard because it's not going to retain water at any point. But here's a picture of the update of where they fixed the fence. And that's just the other side where the fence was damaged that they fixed as well. So at this point on the 5th, it was put into compliance, and the respondent is here today to discuss.
Was the fence the only violation?
It was a fence in the pool, and they
Okay.
either had to put a fence up or take care of the pool. The pool is damaged to where it's no longer considered a pool. There's no way it's gonna hold water. I apologize, I didn't get a picture put into that. So that one's pretty much complied as of the 5th, and the fence was taken care of and fixed the damage, so we're good to go on both on the 5th.
What about the overgrowth and weeds? That's all taken care of as
We
well?
abated that, so we weren't, I think that wasn't in the original order. I think it was just the pool and the fence.
Okay.
But they did cut it while they were out there on the 5th, so.
So from the city's standpoint, there is no active violations?
Correct.
Okay, all
Correct.
right. And
Yeah.
this gentleman is here?
Mm-hmm.
Hello, good afternoon. He pretty much said everything I was going to say.
What was your name again?
It's
You were-
Bobby Mims, sorry.
Yeah, Bobby Mims?
794 Bergham Place, Lake Mary, Florida.
Okay, all right.
But
What's
he
your
pretty much-
relation to the owner, by
I'm
the way?
representing SunWest or their asset management.
I got you,
company.
okay.
They just put it across my desk yesterday evening, so.
And told you to be here?
She wanted, yeah, she highlighted an email, and Mr. Jim, I believe, he pretty much said everything that they wanted me to say. So they just are curious on what the fines are going to be. And also, there was some issue with it. The initial notice, I think back in December, went to the
Yeah, there was a timing issue when the notice was sent out versus when the certificate of title was issued, because I think the notice went to the mortgagee, which was SunWest, but the certificate of title was Pink Trust, which is an arm of SunWest, but
out of Puerto Rico.
technically, if they're the owner, they should have gotten notice. So that's why we pushed it back. But I think I see that's been rectified now.
Yeah, yes,
But-
and I've got like a 52-page report with all pictures. They cut everything. Everything is, should be in compliance and looking good. And that tenant, once the eviction is done, we plan on getting it on the market and fixing
So
it.
do you know what the status is on the eviction?
I believe that was filed on the 19th, and I do not know. Like I said, this just came across my desk literally 9 p.m. last night, so I'm
That's
not
fine,
really sure
that's
on
fine.
that. I know I did actually have a cash for keys agreement signed with that
Mm-hmm.
occupant at one point in time, and that ended up falling apart
Okay.
right at the last minute. And I've got the eviction filings as well, or the complaint for eviction.
Officer Jim, do you know when the property was brought into compliance?
On the 5th of March.
The 5th,
Fifth.
last week.
Last week? Okay. Okay. Yes, the original order said the fence needed to be fixed by noon on December 5th, or we may impose a fine of $100 per day commencing December 6th. But even at that time, we knew there were issues with the mailing and the technicalities involved. So I don't think it would be fair to calculate out $100 per day for the last 3 months.
And the current occupant has been pretty tough to deal with.
Yeah,
about.
understood. I'm not going to impose a fine, but we will have to recover the costs that were imposed. which is only $189.11. As long as, obviously I understand the difficulties with, as far as like the eviction and not really technically being able to enter the property to do these fixes. And then you tack on all the potential notice issues as well. I don't think it's fair and proper to impose those fines. The fact that you guys were able to, pursue the eviction and also get the fence fixed during that interim period, I think that speaks volumes. So I'm going to make my ruling. I find that based on the evidence and testimony presented, that notice was properly provided to the respondent, and respondent did appear. Can you make sure they have your name and address? We got to make sure we have it documented who appeared on behalf of the trust. The evidence demonstrates that the property located at 218 Ojibwe is no longer in violation, and the property is in compliance with the previous order from November 13th, 2025. No fine will be imposed. However, the cost of $189.11 have not been paid and will be due from Pink Trust. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement. Oh, sorry. No, that's not applicable. So once you get a copy of the order, make sure you guys pay the fine. They're not fined the charge. Yeah.
They're good.
All right. And
Thank you.
all right. Thank you, sir. Appreciate it. Give me 1 second. Let me organize here a second. Okay, we'll move ahead with 26-03, which is 1235 Thoreau Street.
I didn't know if you needed to do the final order on that last case.
Yeah, yes. Do you not want me to?
So I have two exhibits. First is the notice of hearing and affidavit for today's hearing, and the second is the cost recovery statement, $153.89.
Thank you.
So once again, this is the noncompliance hearing for case number 26-03. Our respondents are BAF Asset 6 LLC and Corporation Service Corporation, the registered agent. Our violation address is 1235 Thoreau Street, and we have mailing addresses of Austin, Texas for the owner and Tallahassee, Florida for the registered agent. Let's see.
Are they present, by the way?
No.
Okay.
So I've got 5 violations right now that are remain in violation. That would be section 6-56 for a building permit required, 304.13 for the windows, skylights, and doors, 304.6 exterior walls, 506.2 sanitary drainage, and 603.1 for the mechanical appliances. The electrical section, 605.1, and then roofs and drainage, 304.7, was placed in compliance on Friday, March 6th. So our certified and first-class letters were mailed on February 4th, 2026. Certified mail for the registered agent was signed for on February 9th, and the property owner signed for theirs on February 10th of 2026. And copies were posted at City Hall and hand-delivered to the new tenant of the property on February 24th, 2026. So this case was originally heard January 12th, 2026. No one was present for the respondent. They were found to be in violation of 6-56, 605.1, 304.13, 304.6. Okay. And they were ordered to correct the violations on or before noon of March 6, 2026. A fine in the amount of $100 per day per violation to be imposed commencing on March 7th and continuing daily, and administrative costs in the amount of $153.89 were imposed. So while posting the notice of hearing at the property, that should say February 24th, 2026, I observed a new tenant had moved into the property. Knocking on the door, I was able to speak with Ms. Thorne about the open code case and the open violations, and she had advised me that those repairs had yet to be made. On February 3rd, 2026, the administrative costs were paid in full. On March 3rd, 2026, I received an email from Kim Lewis with Main Street Renewal. That is the property maintenance company. With photos of work done at the property, I requested an on-site meeting to view the repairs. And the final date selected for the reinspection with Main Street Renewal was March 11th, 2026. Ms. Lewis was made aware that the compliance hearing was this last Friday and that there would be a non-compliance hearing today. I did stop by the property on March 6th. Ms. Thorne was home and she did provide access for me to do an inspection. 2 violations were placed into compliance. All the other 5 were remaining, and a review of building department records. As of this morning, there has been no permit filed for the mechanical system. So this is the compliance photo. We had a light in the living room, dining room area that was not functioning. It was functioning on Friday. And then on our roofs and drainage, they did go ahead and add a rain cap and a rain chain to act as the downspout for the gutter at the front of at the front door. So this was the repair of the sanitary system. This is a temporary repair. This is not a permanent repair. And as such, I did not place it into compliance. Also, they did not address all the erosion in the yard. So the only piece of the exterior that was repaired was the frame around the sliding glass door. The rest of the boards, as you can see on the photo on the right, is still rotten and deteriorated. No work started on the west side of the building. Again, no permit application has been made for the mechanical system that was installed. No work has been done inside the house to address any of the damaged interior surfaces at the doors. And no other work has been done to address weather sealing the doors. So as of today, 6-56, we do not have a permit applied for or issued. For subsection 304.13, we do not have the doors being weatherproofed and the interior surfaces repaired. For 304.6, the exterior walls, We still have deteriorated materials on the exterior of the house. Sanitary drainage, the drain line needs a permanent repair and the erosion addressed. And then 603.1, we need the mechanical system permitted and all inspections completed.
So Ms. Thorne is the tenant there?
She's the new tenant.
She hasn't moved in yet, though?
She moved in.
Okay.
There, as of February 24th, she said she had moved in approximately 2 weeks prior.
Okay. So they moved in, and then Lewis was the contractor?
Miss Lewis was the regional director for Main Street Renewal,
Okay.
the property company. I met with one of her representatives January 20th.
But they're not related to the owner. They're a vendor of the owner, right?
They're a vendor of the owner. I've had zero
Contact with the owner.
contact with the owner themselves, just the management company.
All right. Okay. Yes, leave there. I find based on the evidence and testimony presented that notice was properly provided to the respondent and respondent did not appear. The evidence demonstrates that the property located at 1235 Thoreau Street remains in violation. And the property is not in compliance with the previous order dated January 15, 2026. Therefore, I find that the city has established a continuing violation of the following provisions. Section 6-556 for a building permit, Section 6-109 regarding windows, skylights, and door frames. That's subsection 304.13. Subsection 304.6 regarding exterior walls. Subsection 506.2 regarding sanitary drainage system maintenance. And subsection 603.1 regarding mechanical appliances. Accordingly, a fine of $100 per day per violation, and there should be 5, commencing March 7th, 2026, and continuing daily until the violations are corrected. The city's costs of $153.89 have already been paid, correct? Yes. They've already been paid. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. Respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. All right, thank you. Before we move forward, can I ask what matter these groups are here for? We can send them on their way. That'd be nice. I'm sure they have other stuff they'd rather be doing.
Yes, sir. They are here for 2607 would be the couple to the left. And 2610, I believe, is Mr. Howell. Both under initial hearings.
Okay. Let's just skip ahead to the initial hearing part, just so we can get them on their way. I know they were here before I was, so, we'll move ahead to theirs. And that's for 905 Clover?
Yes, sir.
Okay, all right, let's go ahead and go to that one.
If you want to come sit right here.
Sorry, making you go out of order.
Here it is. Okay. I have 3 exhibits to submit. The first is the notice of violation. Okay.
Oh, okay.
All right, try that again. The first exhibit is the notice of violation and affidavit. The second is the notice of hearing and affidavit. And the third is the cost recovery statement in the amount of $153.89.
Thank you.
So this is the initial hearing for case number 26-07. Our respondents are Michael Tripp. He's the current resident and registered listed owner of the mobile home. Melvin Zimmerlin and Marion Zimmerman, they are the listed tangible property owner. The violation address is 4905 Clover Lane, Titusville, Florida. We have a mailing address of 4905 Clover Lane, and then as well as 7262 Oak Brook Circle in Portage, Michigan. The violation is section 30-39, tree removal permit required. So the initial inspection was completed on January 6th of 2026. The notice of violation was hand-delivered to Mr. Tripp on January 9th of 2025. Sorry, that should say 2026. Date given to comply was January 28th of 2026. Certified and first-class mail was sent to both addresses on January 13th of 2026. The current resident signed for theirs on the 16th, but we have not received the tangible property owner's information back. Hearings were sent out on February 4th. Copies were posted at City Hall and hand-delivered to the property. I'm sorry again, I missed that date. Was February 24th, 2026. Certified mail for the current resident was signed for on February 2nd of 2026, and the tangible property owner's letter has not been signed for or returned. So a complaint was received for a tree being removed in the Whispering Pines Mobile Home Park without a permit. I completed an inspection on January 6th of 2026 and verified a pine tree had been cut down on the southwest corner of the trailer located at 4905 Clover Lane. While on site, I did speak with owner Michael Tripp, who stated he received permission from park staff to have the tree removed. Spoke with park staff, who confirmed sunup to sundown Bobcat and Tree Service was the vendor that did the work, and they had received a text message stating that they had gotten approval to remove the tree without a permit. No other document was provided to the park. When I contacted Development Services, they confirmed they had not had any contact concerning a tree removal permit at that location. I did speak to Harry with Sunup to Sundown Bobcat and Tree Services that same day on the 6th. He was not aware of this work, but he was going to follow up with the employee handling the contract to find out what was done and what approvals were acquired. On January 8th, I confirmed with Development Services. No one had contacted the city about a tree removal permit. Initial notice of hearing was issued to Whispering Pines Mobile Home Park under Code Case 26-0010. After receiving a copy of the violation, Regional Manager for Parakeet Communities questioned why the park had received the violation, as the trailer owner was responsible for hiring the contractor and having the tree removed. This Assistant City Attorney did review the details of the case and determined the notice of violation should be issued to the owner of the trailer. As provided by the Brevard County Tax Collector's Office, case 2610 was closed and this new case was open. On January 9, 2026, I did meet with Michael Tripp and hand-delivered a copy of the violation notice. We discussed the determinations made about the case, the timeline of the project, and conversations he had with park staff. While on site, we did call James with Sunup to Sundown to, again, go over the timeline, what work was done, and the requirement for a permit within the city of Titusville. James advised that they had completed the bid without the review of the company's arborist, as the tree was under 36 inches and the bid was for residential use. Contact information for Jacob Bigley with Development Service was provided, so that the contractor could speak with them and get guidance as to that permitting process. On January 20th, 2026, Development Services determined that the tree removal permit cannot be issued in this case, and that a hearing with the special magistrate should move forward. I contacted Mr. Tripp by phone to let him know of the determination in today's hearing. So 36-39 is the requirement to obtain a tree removal permit prior to the tree being removed. So this is the Whispering Pines Mobile Home and RV Park on Cheney Highway. At the lower right-hand corner, the yellow circle is where the 4905 Clover Lane is located. So this is 4905 Clover Lane. These were the photos of the tree being removed or post cutting down on January 6th, 2026. So this violation is irreversible in nature as the tree has been removed. And the trailer owner had the tree removed without the required tree removal permit. So we are requesting that at the time of this meeting, the trailer owner is found to be in violation of Code 30-39. We are asking the administrative costs in the amount of $153.89 be imposed. And we're asking for a fine of $1,500 as the violation is irreversible and or irreparable in nature. And I do have Mr. Tripp here.
I do see, give me 1 second. I think I would have had the same question that it looks like the Assistant City Attorney answered before, because the property owner is actually the mobile park operator. What is the Brevard code that you researched and found, Mr. Melito?
Yeah, so there's some strange language that doesn't map up super cleanly with 162 in chapter 723.024 that governs notice within mobile home parks for code enforcement violations.
So it becomes the responsibility of the trailer owner, not
Yes,
the.
not the
Okay.
park owner.
Okay.
And the reason that we referenced the tax collector's website in there is because they had the trailer park owner, and the 162.12 says you can serve either subject to property appraiser or tax
Right.
collector.
Okay. All right.
Good afternoon.
Good afternoon. Go ahead and state your names for the record.
Michael Trupp, 4905 Clover Lane, Titusville, Florida.
Mrs. Tripp, Crystal Tripp. Same residence.
And what was your first name? Sorry, I missed.
Crystal.
Crystal. Okay. How do we spell Crystal? Do we have the right?
Crystal.
All right. You guys hear that? All right. Okay. All right. Go ahead.
Okay,
This all started with their sinkholes under my trailer exposed all the roots to the tree. Tree tipped quite significantly. They cut the roots out in order to fill the sinkholes under the trailer, which was caused from their septic system, which leaked severely and caused the sinkhole, which exposed the roots under the trailer, which they cut and filled in the hole. I went to the park had people come out, their people, and agreed the tree had to go.
Who is this? Sorry.
The park people, the management.
the park,
And then
parakeet.
they told us to go ahead and call a arborist, which we did. And the arborist came after the hole and the roots were cut and everything was filled. They had to re-level the trailer and do all that. And we asked the tree guy state license by the state of Florida, he said a permit wasn't required. Now, we didn't cut the tree because it's
I've
a
got it.
tree.
I've
We
got it.
cut the tree because there was a sinkhole under the trailer. They cut the roots to fill the sinkhole. Therefore, I felt as though it being a pine tree, it was weakened even more. And it was already leaning, and when we bought the trailer 2 years ago, it was straight. And the trailer sunk 2 inches, and
That was after that rainstorm we
Yeah.
had.
that's all I got to say. I went to the park that day.
We have
And
proof
told
here
them they
that
were
we do
coming.
not need permits right here. The arborist said we do not need permits because it's so close to the house and leaves are coming off the tree over our home and are considered a threat to our property. So it said we did not need it. And then if you look up here, it says Florida state statute, local permit is not required if property owner has written notification from a certified arborist or Florida licensed landscaper. Sorry, I'm very nervous, stating that the tree poses an unacceptable risk. That's why we didn't get a permit.
Took the tree down because there was a sinkhole under the trailer. We were in fear of our life that time, sir.
His
The
bedroom was
park,
under the
the
tree.
park even acknowledged that the tree had to go, but they would fail to respond or do anything except telling us to get an arborist. Other than that, we would have got a permit to cut the tree.
Definitely, we would have got
We
a
did
permit.
not know we needed a permit to cut the tree.
Who is this, or who is the contractor that told you didn't need a permit?
Sun up until sundown tree service long here.
Have you talked to them afterwards and told them, hey, gave us wrong information? What?
No, he's the one
Well,
that-
the enforcement officer talked to him.
No, that's what they told us, we didn't need a permit.
I mean, I'm not saying you guys weren't acting reasonably. In your shoes, if an expert or whatever told me, or a purported expert told me I didn't need a permit, this is the vendor I'm supposed to use, I would believe them as well. But that's not the case. And this person gave you
You-
improper information. And would you have a complaint against him? That's not for me to say. I would be in your shoes pretty upset with him. I would be upset with the park that makes you use him. But I don't have jurisdiction over any disputes you may have with them. It's sort of a black and white thing for me where all I can say is whether or not a permit is required, and I do believe that it is, and whether one was obtained, and I don't believe that one was. All the other circumstances around how you guys ended up in this situation, again, I sympathize with you, but I can't rule and say that there is no violation. You see what I'm saying?
I looked it up and it said, when I looked up what I had to do to what required a permit.
Officer May, do you want to reiterate to them what the,
Yes, this Florida statute for 163.045 references single-family dwellings.
yeah.
And the trailer is located within a mobile home park. It is a commercially zoned property. So, as explained to me by Development Services and our arborist, Jacob Bigley, this property does not fall under that
Right.
exemption under 163.045.
Can you explain to me how you came about the calculation of 1,500? So I see in the original packet, the original recommendation was significantly more. I see you've now reduced it to 1,500, and I was just curious if there was a science to it, or you did it out of consideration for their situation, or?
Yes, sir, for their situation.
Okay. So the original recommendation from the city was a $5,000 fine. It's obviously significantly less, but, telling someone that 1,500 is affordable is not what I'm here to do. But I am, I'm unable to do a ruling other than a permit is required and it was not obtained, okay?
That's true.
All I have any discretion on is the, whether or not I agree with the city's recommendation to impose the fine of 1,500. And again, it sounds like the reason why you wanted the tree removed wasn't because, hey, you just thought it would look prettier without a tree, or you were trying to circumvent the process in any way. So I do sympathize with you. I do think you have a valid complaint about,
I do have
against this.
I do have photos
Yeah.
to show you how close it was to the
Right.
trailer.
Yeah.
Didn't realize the wording that we wasn't residential, that we're
Right,
commercial.
right.
That too.
But again, I think all that research and stuff you probably did after the fact. You just relied on the word of another person.
Oh, yeah. Can I also state that I'm a retired medical assistant. He's a retired union electrician. We understand permits and regulations. We do. We would have never gone against this. We would have gotten the permit. We would have done what we had. I read this and thought my butt was covered. And again, he did say we did not need a permit.
All right. Okay, so I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that Respondent Michael Tripp is the owner of the trailer on the property located at 4905 Clover Lane. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that a violation of Section 30-39 of the City Code, which requires a permit for tree removal, exists upon the property, and that the nature of the violation is such that it is irreversible. I find that the city has incurred costs in the amount of $153.89. Such amounts shall be included with this order. I'm going to reduce the city's recommendation of $1,500 to just a flat $1,000. And respondents shall be given 90 days from the date of the order to pay the fine. Respondent shall be responsible for notifying Officer May or code enforcement officer of the payment of such fine. A certified order may be recorded in the public records of Brevard County. It is so ordered. I didn't like having to do that because I really do sympathize with you guys. I do think that having this put into writing gives you something you can go back to your park operators and say, hey, your people have some liability for this. I'm not in a position where I can give you legal advice on that, but there's certain legal concepts of detrimental reliance. You relied on their statement reasonably and justifiably. And yeah, that's the best I can do.
Thank you, sir.
All right. Thank you. All right. And this gentleman right here, we're going to move on to his.
Yes, we're going to
Which
move
one
to
is it?
case 26-10.
Okay. And that is 4745 Apollo Road. All right.
So I have 3 items to submit. The first is the notice of violation and affidavit. Second is the notice of hearing and affidavit. And the third is the cost recovery statement in the amount of $206.72.
Thank you.
So again, this is the initial hearing for case number 26-10. Our respondent is Mark Howell. Our violation address is 4745 Apollo Road, Titusville, Florida. Our mailing address is 4141 JD Drive in Mims, Florida. And we have two sections in violation. It's 6-109 subsection 304.1 for general exterior maintenance and 301.3 for vacant structures and land. Initial inspection was completed May 29th, 2025. The notice of violation was posted on June 5th, 2025. The respondent was given until August 5th of 2025 to come into compliance. Certified and first-class mail were mailed June 6th of 2025, with the certified copy being signed for on the 18th of June. The notice of today's hearing were mailed on February 4th of 2026, and the certified copy was signed for on February 9th, 2026. Notices were also posted at the property and at City Hall on February 24th, 2026. So the Titusville Fire Department responded to a call for a vehicle on fire inside a building on the property on May 25th of 2025. While on site, the fire department requested the building department be notified for a possible condemnation of the building. On May 29th, I completed an inspection of the area, observed the metal building with the front door hanging off its hinges. The exterior walls and windows and roof were in an advanced state of deterioration. I contacted, and I did not see any sign of the fire from the roadway, nor did I see any placards from the building department on a visit to the property. The site was overgrown, and there were signs of transient activity, including graffiti and trash and debris on the property. I did contact the building department to follow up on the fire call. I was told that a building inspector would be out to evaluate the structure, and they would notify me when they made a determination on the building. I did also speak to Mr. Howell by phone to let him know of the fire and the pending building department inspection. June 5th, 2025, I received call back from Deputy Building Official Martin Abel concerning their inspection. They determined that there was no imminent danger to the public as the gate to the property was locked and the building was set back from the road. And they indicated that code enforcement should move forward with a case addressing the current conditions of the property. I did return to the property and post the notice of violation. So I've been in contact with Mr. Howell all the way since last May. I did meet with him August 6th, 2025 on the property to discuss the plans for resolving the violation and the next step on the case. He indicated that he would be meeting with the building department to discuss alterations and guidance on the minimum requirements to bring the structure into a safe condition. In October 2025, Mr. Howell indicated over the phone that he was moving forward with obtaining an alteration permit to repair the structure. So a signed permit application was submitted on December 4th of 2025 for an alteration permit. There were review comments emailed back to the applicant on December 12th, 2025, requesting that plans for the repairs as submitted on the application be turned in for review. At the time of today's meeting, no supporting documents have been submitted on that permit application. So the results of the building, there hasn't been any work to the building itself. Graffiti that was on the building has been covered and it's been maintained. There's no new graffiti. The door remains open. The exterior walls remain damaged. My inspection on Friday, the 6th, trash and debris continue to accumulate. I did see an individual on the property, and he did run off before I had a chance to speak with him, and the property is also overgrown at this time. So this is an aerial view of the property located at the south end of Apollo Road. This is the gate as determined by the building official. It does stay locked. This is a close-up of the front door and the side of the property, of the exterior wall. This is the south side. And this is a photo of the interior taken during my August 6th visit with Mr. Howell. So conclusions in this case for 304.1, exterior walls, roof assembly, doors, windows are deteriorated with holes, and there's many missing materials. And the structure is not sufficiently secured against entry and is continuing to be used as a place of harborage. Trash and debris continues to accumulate, and there is overgrowth at this time. So we are requesting that the respondent be ordered to correct the violation on or before noon of May 8th, 2026. To come into compliance, we are asking that a permit be obtained to return the building to a structural sound condition capable of preventing elements, rodents, vagrants from entering it. Or a permit to demolish the building and returning the site to natural topography. And then for section 301.3, we are asking that the property be maintained with the removal of overgrowth, trash and debris, and continually inspected to make sure that it is not being used as a place of harborage. If the respondent does not comply, we are asking a fine of $100 per day per violation be imposed commencing on May 9th of 2026 and continuing until the violations are corrected. And we're asking for administrative costs in the amount of $206.72 are imposed. And Mr. Howell is here to speak on behalf of the property.
For compliance, are you looking to have the permit issued or the work done pursuant
Permits
to-
issued.
Okay. All right, Mr. Howell?
Basically, we're just here today because there was a fire, and then we're moving forward with that. On February 21st, I wasn't, as she had said, she had let me know about a fire on my property, everything else. Recently, on February 21st, there was another fire. I have pictures of that, where there was a fire on my property and the state's property. I still yet to not be notified by anyone, by the city or anyone else. That's just something that I wanted to point out in this situation. Just as she stated, the state and the building department said that the structure is far enough and it's gated away that it doesn't need to be demolished or anything like that. So I didn't know what else needed to be done. I had asked before with the city or May to help put some of these things into compliance with the building itself. What if I put a fence around it? Would that help from people going into it, the doors, the structure because of the back of the building and so forth, as she had stated? Do I need to put multiple fences around my property in the structure? I mean, because there's already one. Do I need to put another one behind it to justify or satisfy those situations?
Tell me this, so I see you've owned the property since 2014. How long has it
Correct.
been in the condition that it's been?
Since 2014, and I brought, there was probably $110,000 worth of liens and fines with the property because there was a trailer and a lot of things that I have pictures here from today that I cleaned up and did the property within 3 weeks. Every time there's something that's noted or a eyesore or distraction or something that it needs to be taken care of, I usually do that and take care of the situation in a accordingly amount of time. Since this last thing that has been done, I mean, my goal was to pay off the property. Within this past year, I paid off that property and did that. So I was trying to move forward with the next goal, and then a fire on a Saturday night happened by some kids, and I was called by neighbors. That's how all this came within since 2014, and it's 2026 about this building. Again, the city didn't say that it needed to be, well, the building department didn't say it needed to be knocked down or anything because of the structure or anything else. It only happened because of a fire that occurred in the middle of the night. I'm asking to try to get a 6-month leeway to try to move forward with the plans of either most likely demolishing the building and having all those things in compliance and taken care of. So by September 9th, I would say.
So you did submit an application, though,
To
in December.
rehabilitate the building. I was going to try to put the building back in because it's not demolished. It hasn't been ordered to be condemned or anything else like that in the nature. So I was going to try to rehabilitate the building. And then once going further within the past 6 months, once the fire happened and everything else, and accumulating costs and talking to contractors and getting people to go out there and trying to figure out the things, I don't know if it's cost efficient enough to move forward and put $150,000 to $200,000 into a building that, you know, we might be able to use the 7 acres of property to help with the city and other aspects than just rehabilitating a building for personal use or anything like that.
Right, but, understood, but is not the other option then to demolish it?
That's what I'm going to do. Yes, sir. So that's why I'm asking for 6 months to have the permits demolished, everything in compliance. Instead of until May 2nd.
Why
2 months.
6 months?
To get things done in accordingly amount of time. For funds and everything else to demolish a 14,000 square foot building.
Right, and I'm not saying this to, you know, to be a jerk or anything like that, but didn't you already have funds allocated before when you had the
To try
plans
to
to
move forward to
rehabilitate instead?
investors, yes, sir. Not personally. And then once talking to the city and going further with the rehabilitation, it takes more than, whenever you rehabilitate the building, you can't actually, it goes into another part. And I spoke to other people that are running into the same problem on 405 with the building. Once you rehabilitate the building, it's not in conditional use or up to, it's technically to code. I'm trying, hard to explain. Basically, once you fix the building, you have to jump through other hoops to be able to actually use the building.
Of course.
Yes, sir.
Right.
So under that.
And I know you posed a question to me before, and I don't think it's my purview to answer about what other things you could do, maybe other fencing. I think that's a building department question, or I don't know, Officer May, if there's any other options, but that's not for me to decide, right? So my decision is whether or not there's a violation, and clearly there's a violation. But were there other options for him other than full demolition of it or rehabbing the property? He had mentioned something about more fences, or I wouldn't even know anything about that.
So for securing the structure,
Yeah.
I had just asked as a part of this order that regular visits are done to the property, as he is correct. There is a gate, there is a fence around the exterior, but people do continue to enter in.
Of course. Yeah.
And we still have people accessing the building. I have not discussed an additional fence with Mr. Howell, but if he wanted to install a fence around the perimeter of the building, I would not have any issue with that being a method for securing, provided he continues to do maintenance on the property, mowing, removing any trash and debris. As far as getting a permit to install a fence around the perimeter of the building, that is indeed a building department question, and I
Yeah.
don't know what they're gonna
Right.
require.
Right.
I had to pull a permit to put the initial fence in first, so I'm sure that there would have to be a permit to be pulled to go around the building. Yeah, that's,
My gut says yes,
I'm
they're
just
gonna
wanting
require it,
to take
but
it down. That's the main thing that I'm gonna end up doing, is just take it down and make it safe. And then move forward with any other plans that I'm entitled to. And not that it's your concern or anything else, but the beginning of May and trying to get that done before my two kids start summer, I would rather try to do that at the end of summer. Just like it was harder to plan vacations during Christmas time and get things done in compliance.
What was the time frame recommended by the city?
2 months, May 9th. I was asking for September 9th. Get summer to get over, school to start, and me to have my stuff finished.
I'm not necessarily inclined to agree to 6 months, just because, I mean, again, the time that this has been on your radar, at least, is something to take care of. The fact that, I mean, you've owned it well over a decade at this point, and obviously I know there's other priorities and other financial obligations that you're dealing with, but.
My goal was just to pay it off. I did that this past year.
I understood, but, there's certain
Yes, sir.
responsibilities that come with owning
100%.
property, and these pictures look, I mean, obviously it's not a condition you would want it to be in either,
Yeah.
right? Like, you wouldn't have
The
invested
last
any
hurricane
money
is whenever
into it
the
at all.
roof came in and stuff like
Um,
that. So then I was devastated when
yeah.
that situation happened, and then just trying to move forward with that.
The worst thing that could happen is to give someone 6 months, and then they wait until the 5th month to do something, and then they're back again saying, we submitted the permit application, we just haven't heard back. And
That's-
so,
That's why I was saying over in the decade that I haven't not taken care of situations in the decade that I've owned it.
um,
I mean, this is the first thing, and
and again, the other aspect too is the city's only asking that the permit be issued by then, not necessarily that the work be completed.
yes, sir.
And while I understand, the timing concerns with family and everything, I don't see it being an issue to get a permit application in. I don't think that should interfere with your vacation plans. So I will give you 3 months instead of the 2 that's requested by the city.
Yes, sir.
Now, let's say 3 months from now, a permit application is in. It took you a little bit longer to get it in because now you decided, hey, I do have funds from investors to rehab it. I need to change gears and stuff like that. We come back here in the compliance or a non-compliant hearing, and you say, hey, it's all being processed right now. I've been in regular communication with Officer May. I've been removing the debris, everything like that, and mowing the lawn. And of course, at that time, it would make sense, hey, we'll give you additional time to get that done. It's just I don't want to commit to 6 months because I know that as soon as you give someone that amount of time, they take that amount of time.
Yes, sir.
So, Officer May, you look like you're itching to say something.
Just wanted to make you aware that as of right now, the June 2026 hearing will not take place.
Yeah, why is that? Oh, yeah, that's right. So, I mean, well, we'll put it down, so that's good for you. So technically, you need to be done by that June hearing, but I won't be in town to hold this meeting, but let's not officially put that down. So you have time to get
Yes,
this
sir.
done, and yeah, please give it the attention it deserves, because I was looking at Google Maps and some of the pictures of it historically, and it's looked pretty bad for a while, so.
Oh, yeah. No,
Um,
I fully agree, and I'm not disagreeing. So I'm going to move forward and hopefully fix all those problems.
I've accepted and considered documentary evidence, including photos and sworn testimony relating to the matter from city staff. I find that respondent Mark Howell is the owner of the property with the address of 4745 Apollo Road. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of sections, is it all 4 of these sections that are on this notice here?
No,
The-
sir, just two.
two.
It's going to be the exterior walls and the
Sorry,
vacant
let me
structure.
make sure I quote the right ones. Okay, the vacant structure and the exterior walls, right?
Correct.
Okay, sorry. Sections 6-109, subsection 304.1 regarding general exterior maintenance, and subsection 301.3 regarding vacant structure and land exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective action at this time shall be submitting and having issued a permit for either the rehabilitation or demolishing of the property. Or if there's an alternative that you are able to work out with the building department. Either way, a permit needs to be issued to fix it.
Yes, sir.
Additionally, I find that the city has incurred costs in the amount of, I had it out here, $206.72. Such amounts shall be included with this order. Respondent shall be given until, do we have that date? That's 3 months from now?
Give me 1 second, sir.
Yeah, sorry. That's my fault. I didn't have that up. June 5th, 2026, to correct the violation or to have the permit issued. Respondent shall be notified for, responsible for keeping the code enforcement officer updated on the progress. If respondent fails to correct the violation by June 5th, a fine will be entered in the amount of $100 per day per violation until it comes into compliance. Further and future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you, sir.
Yes, sir. Thank you. Thank you, man.
All right. Why don't we get back to our regular scheduled programming? Unless
Yes, sir,
you
that
have
would
something
take
else.
us to case number 2604.
All right. Yes, 1780 Gulf View Drive, a non-compliant hearing.
Sir, have the notice of hearing for this today and the cost affidavit for $206.
Thanks. Remember this name. What was this one?
Again, this 1780 Golfview Drive, there's 5 violations on the property: the exterior sanitation, the overgrowth, the general exterior maintenance, interior surfaces, and the general interior.
Oh, this was the cat house, that's right.
This will
Okay.
be the cat house, yes, sir.
All right. Are
notice
they
of
here?
re-
Are they here? Have you communicated with them at all?
No, have
All
not.
right, okay.
No communication, no nothing, nothing's been done. The only thing I can say is the gentleman that was staying there has moved out. But the condition of the house remains the same.
Yeah, good. All right.
I don't know if you want to see the pictures again or not. Okay.
Oh. This is like a nightmare.
That's all I got for you, sir.
All right. Yeah, I'm just looking through the agenda packet you sent. It's just amazing. All right, I find based on the evidence and testimony presented, a notice was properly provided to the respondent. Respondent Patricia A. Tooming did not appear. Evidence demonstrates that the property located at 1780 Gulf View Drive remains in violation. Specifically, it looks awful. But more specifically, let me make sure I have the right 5 ordinances that were, hold up. It's not on the screen, okay. We have subsections 302.1, exterior sanitation, subsection 302.4, overgrowth and weed, 304.1, general exterior maintenance, 305.3, interior surfaces, and 305.1, general interior maintenance. Accordingly, a fine of $100 per day is imposed per violation. Those fines commence on March 7th, 2026, and will continue daily until the violations are corrected. Additionally, costs of $206.72 have not been paid and will be made part of this order. A certified copy of this order will be recorded in public records constituting a lien on the subject property. Respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. I'm sure this person will one day file a lien reduction application and say she didn't know.
Probably the new owner.
All right. For 3446 Trevino Circle, we still need to hear that to have an order issued, correct? Officer Glenn? Yeah.
Yeah, that was
That's correct,
corrected.
sir.
Okay, all right,
It was corrected 2 days after the hearing, so we're good.
okay. All right, so for 26-05, which is Solomon Family Trust at 3446 Trevino Circle, I find that based on the evidence and testimony presented, that the property has been brought into compliance. Have they paid the city's costs?
No, sir.
Okay. What's the city's costs?
171.50.
Okay. However, the costs of $171.50 have not been paid. That doesn't become a lien, right? How does that work? You just get invoiced for that? How does that exactly work if there's no like fine or anything? Who keeps calling?
Not entirely sure. I don't think I've encountered that before. It would be a
Let me see.
result of the violation. Let's see what 162.
Is the cost only imposed if they are non-compliant after the? Let me see.
I believe at the original hearing, she was provided 6 months to pay cost.
Yeah.
We do record those as liens.
Okay. All right. So. All right. So the costs of 171, whatever, what 50? 171.50 is that what it was?
Yes, sir.
Have not been paid and will be due from the owner. Certified copy of this order will be recorded in the public records and may constitute a lien on the subject property. Respondent is required. Oh, that doesn't make sense. Okay. All right. It is so ordered. All right. I think that brings us to, all right, 2608 is done. That's removed. And then so we just have 2611, which was 4480 Byron Avenue, I believe.
Yes, sir. So I have 3 items to submit. The first is the notice of violation and affidavit. The second is the notice of hearing and affidavit. And the third is a cost recovery statement in the amount of $206.72.
Thank you.
Once again, this is the initial hearing for case 26-11. Our respondent is Edward C. Baker. This is the estate of. Our violation address and mailing address is 4480 Byron Avenue here in Titusville. And we have 2 violations, section 12-23 for junk and debris, and 13-26 for overgrowth. So the initial inspection was completed August 7th, 2025, and the notice of violation was posted at that time. Date given to comply was August 22nd of 2025. Certified in first-class mail was sent on August 12th of 2025. The certified mail for the listed owner has not been signed nor returned. The notice of hearing was posted at City Hall and on the property on February 24th of 2026. The certified mail was mailed on February 4th and returned sender deceased on February 17th of 2026. So while I was driving in the area, I just observed grass and weeds in the yard over 12 inches in height. There was a large accumulation of trash and debris as well as furniture in the driveway and along the front of the house. Photos were taken for the property and the notice of violation was posted on the front door. At the start of this case, I had confirmed that Mr. Baker had passed away, but his partner, Kenneth White, had been seen at the property by neighbors. All attempts to contact Mr. White and Mr. Barker's estate have been unsuccessful. There's been no change to the condition of the property. So this is a photo of the front yard and the junk and debris. This is another photo of the front yard. This is the trash and debris. So I have seen the trash cans move. Some of the trash get picked up and moved around. That was my indication that there was people still coming to the property. In February, the mail carrier on the 24th did stop and say he has been made aware that Mr. White is also deceased in the last several months. I had made contact with HUD. They had taken over the loan, the mortgage, and as of my last contact with the representative, they were trying to do a reinspection of the property to take over custodial care as they hadn't officially started the foreclosure procedures. So I do believe the neighbors may be the ones that are moving the items around the yard. So the conclusions for this case, there is a large amount of furniture, trash, junk, and debris on the property. Vines, bushes, trees are growing up against the house, and the grass in the yard is well over the 12 inches of violation height. I'm requesting that the property come into compliance on or before April 10th of 2026 by removing the trash and cutting the grass and removing the vines, trees, and bushes. We're asking the administrative cost in the amount of $206.72. And we're asking for a fine of $50 per day per violation be imposed on April 11th, 2026, continuing daily until violations are corrected.
So it's true. You really do just drive around and violate
Just
people, don't you?
randomly, just
like,
find violations. Yes, sir.
This is, you must be popular.
Oh, I make friends every day.
All right, I have accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent Edward Baker is the owner of the property of the address 4480 Byron Avenue. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of Sections 12-23 regarding junk and debris and Section 13-26 regarding trash, dead trees, and overgrowth exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. Additionally, I find that the city has incurred costs in the amount of $206.72. Such amounts shall be included with this order. Respondent shall be given until, what was the date? What was the date we gave? Sorry, I need to know these better.
I think it was April 11th.
April 11th? Okay,
April 10th.
let me see.
I wrote down 11.
April 10th is a Friday, 11th is a Saturday, so 10th.
April 10th for compliance, and then,
11th for the imposition of the lien. I
yes,
mean, the
please.
fines, yeah.
yes.
Respondent shall be given until April 10th, 2026 to correct the violations. Respondent shall be responsible for notifying the code enforcement officer of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by April 10th, a fine will be entered in the amount of $50 per day per violation until they come into compliance. Further, in future violations of the same section shall be classified as a repeat violation. Certified order may be recorded in the public records of Brevard County. It is so ordered. Okay. I think that's it, right? Okay. Do we have a report from the code enforcement officer?
No, sir, just wanted to thank you for coming Saturday and helping us with our event.
Thanks for the food. That was great.
And Mickey for coming today as well.
All right. I did hear that we are actually moving forward with foreclosing on some liens. Yes. That sounds exciting. Is that a?
We have a couple in the pipeline that we're looking at. Make sure, no homesteads and get all our ducks in a row, all that fun stuff.
All right. Yeah, that's good. I mean, I think obviously that's the most powerful tool for collecting on liens. So, all right. Well, if there's nothing else, I guess we're adjourned for today. All right.